Hello, my name's Tom Kurys. I'm an intellectual property lawyer and patent and trademark agent at Wilson Liu LLP in Toronto. And I'm going to give a quick high-level primer about intellectual property law in Canada. It's a lot to cover in just a few minutes, so I'm only really going to scratch the surface. If you've come up with a new product or service, or you have a great idea for one, you might be wondering about IP and what kind of protection, if any, you should get. When you think about IP, there's really four types: patents, trademarks, copyright, and industrial designs. And I'll go through what the differences are, starting with patents. So patents protect inventions that are new, non-obvious, and useful. And patents aren't limited to physical things like machines or chemicals. You can also get a patent for a process or method. So in other words, a way of doing something. There are things, though, that you can't get patents for, like methods of medical treatment or scientific principles. If you decide you want a patent, you need to file it in individual countries or regions, like Canada, the US, Europe. There's no such thing as a worldwide patent. And if we consider Canada first, after a patent application is filed, it usually takes at least a few years for the patent to register. The patent office is going to look at your application, see if it meets the requirements for a patent. And there's usually a bit of a back and forth with the patent office about that, and you often need to make some amendments to your application before it registers. If the office decides that it is patentable, your valid patent will last for 20 years from the filing date. And you get this monopoly over what you've claimed for the life of that patent. And in exchange, what you've done is disclose to the public how your invention works. And when the patent expires, others are free to practice that invention based on what you've disclosed. So because of this, some inventors prefer not to file a patent application to keep their innovation a secret. It's known as a trade secret. And they'll do that in some cases if they think no one else will be able to reverse engineer it. So I'm sure you can think of some famous beverages with secret recipes. Let's move on to trademarks. A trademark is something that you use to distinguish your goods and services from the goods and services from others. It's your branding. And a trademark can take several forms, the most common being a word mark like Nike, or a logo. Think of the Nike swoosh. And trademarks can exist in other things, like the shape of an object. Think of the Coke bottle, or even a distinctive sound like the MGM lion roar. Trademark rights in Canada can arise from registration in the Trademarks Office and also just through use in the marketplace. If you file a trademark application, you're going to need to list the goods and or services that you're going to use the mark with or that you already use the trademark with. Once the trademark registers, you then get the exclusive right to use that mark with the goods and services in the registration anywhere in Canada. And your registration is going to be valid from 10 years and it can be renewed indefinitely. Apart from the registration process, trademark rights can arise through use in the marketplace, and those rights exist wherever the trademark has gained a reputation. And these unregistered rights can then be asserted against others who are trying to pass off their goods and services as your goods and services. Moving on to copyright. In Canada, copyright provides the owner of an original work with a bundle of rights. It includes the exclusive right to produce or reproduce the work or a substantial part of it. And we're talking about literary works such as books, dramatic works like plays, musical works like songs, or artistic works like paintings. And the threshold for what is an original work is pretty low. You don't have to be a good artist in order to get protection. The Copyright Act also provides some protection for sound recordings, performances, and broadcasts. Unlike a patent, copyright protection automatically subsists in the work and it doesn't need to be registered. As soon as an original work is created, it is covered by copyright. Registration does, however, provide a presumption that the copyright is valid, and it could help establish when the work was created. Also, unlike patents and trademarks, where knowledge of the patent or the trademark right is not necessary for finding of infringement, copyright infringement requires actual copying. So two people can independently create an identical work and they would not be infringing each other's copyright. Copyright in works lasts for a long time. It lasts for the life of an author, plus 50 years after they've died. Or if there's more than one author, 50 years after the death of the last author. And after that, the work falls into the public domain. It can be used by anyone. We can think of the Shakespeare plays, for example. Finally, industrial designs. Industrial designs are about the aesthetic features of a product, the look of a product. For example, if you have a shampoo bottle with an interesting shape. Like patents, industrial designs must be registered to be enforceable, and there are requirements for registration, such as a novelty requirement. Registration lasts for 10 years from registration, or 15 years from the filing date, whatever is longer. And it gives the owner of the industrial design the exclusive right in Canada to use that design. So that's a very high-level overview of IP law in Canada.